I'll call the meeting to order. We're running about 15 minutes late, so we'll try and pick that up on the tail end. Our meeting today, well, first of all, I would like a motion to approve the agenda.
So moved.
And the minutes included. Is there a second?
Second.
There is a second to approve the agenda and the minutes. Any further discussion on the motion? Seeing none, all those in favor say aye.
Aye.
Opposed, the same sign. Motion carries. Thank you. And thank you, Commissioner Stein and Commissioner Rothman, for just an excellent presentation on climate change. It was just excellent. You moved it along very nicely. So
Thank you, Mr. Chair.
I want to also compliment you on the way you handled the names. It was just right there. You had a nail, so very good. Excellent. Again, our agenda is relatively short today. Our job really is to determine whether the Michelle and Tracy Erickson 19.11 acre mine site is a phased action to the Minnesota Sands multi-site EIS project. You have in your packet materials, several attachments, number to 12. I'm hopeful that you've had a chance to peruse those attachments. I'm also, I want to just mention that if you have, for those of you that are here for the public comment portion of it, if you have new information that you think the board would be interested in or could use as we move forward with this discussion, please keep that in mind as you come to the table. Again, we have several attachments, including the resolution and finding of fact and conclusion in order for the Erickson site, and on through attachment number 12. So with that, I will ask Executive Director Seifert to have for any comments if he has, and if not, we'll move directly into the discussion.
Sure, since time is of the essence, I'm going to quickly go through just a couple announcements. A number of questions were raised about accessibility of the presentations from the last, from the subcommittee meeting. These will all be posted on our website, so stay tuned and you can get those. Couple things. The rulemaking advisory panel met again yesterday. It is our intent to have a proposal before the board for your consideration and discussion in September. In terms of your own planning, we're looking at traveling off-site for our August meeting, as we'll have our first climate report done then. So we will follow up with details, but just if you can make a mental scheduling note, and we'll be in touch ASAP with some details so you can plan accordingly if you're able to join us. And then just two brief staffing updates before moving on to the agenda before us. We're really excited to welcome Heather Ahrens to our team here on a part-time basis to be our lead on silica sand issues. She starts today. She'll be continuing her work for the DNR too on a part-time basis. I'm going to read her bio real quickly here. Heather is the State Program Director of Industrial Minerals for the Department of Natural Resources and has worked as a geologist for 16 years. She earned a degree in geological sciences, specializing in glacial geology and geomorphology from the University of Minnesota Morris. She's currently completing an MS in geological sciences from the University of Minnesota Duluth. Over the past 2 years, Heather has been working on silica sand related projects. Currently, she's a coordinator for DNR's rulemaking effort for the reclamation of silica sand mines. She'll be still involved in that project, but she'll be leading our silica sand work as well. So feel free to deluge her email inbox as of today.
Mr. Chairman, for the record, this is a temporary. Sure. Back. And, Mr. Chairman, I'd also like to take just a moment to digress. Another one of our great workers here, Melissa is leaving, and we're going to miss her presence here and the great work she's done.
Thank you. Any other praises? Thank you. Well, anything else?
That's it.
Again, then I think we'll just move directly into the discussion regarding the Minnesota Sands multi-site EIS. At this time, does the board, members of the board, have any questions regarding the information that you found within your packet, the 12 attachments? Oh, yeah, that's right.
Mr.
Yeah,
Chair?
of course, if we're going to get there regarding the packet. Yes.
I believe
Commissioner Stein.
I was the one who made the motion at the last meeting to put the matter on the table. I believe it's, in order for us to reevaluate that, I should take the matter up and bring the matter up before the board. So I'd like to take the matter, I move to take this issue off the table.
Motion to remove from the table.
Second.
Is there a second? There is a second. I believe that we're able to discuss it. Is there further discussion on the motion? Seeing none, all those in favor say aye.
Aye.
Opposed, the same sign. The motion carries. Now, Commissioner Stein.
So, Mr. Chair, the last meeting, my reservations about taking action on this question were in part because it was unclear to me what the county and the owners of Minnesota Sands and the property owners' intentions were. And there was a significant amount of testimony from members of the public and from representative of the county, representative of the company and the property owners that didn't quite seem sufficiently clear to me to bring the matter up for a vote for the board. I would note that, you know, in the intervening period of time, there's been a lot of communication back and forth. The Planning Commission of the county has met and heard this matter, and there's even been some level of court intervention that is documented in attachment 12. Seeing all this, it's more clear to me now what the intention of the county, what the intention of the company and the property owners are, so I'm comfortable making a decision today. I think that there are still some questions that we should discuss as a board. My first question would be for Commissioner Landwehr. I noted in attachments 10 and 11 there's an exchange back and forth between the DNR and the county regarding the applicability of the trout stream setback permit for the Erickson property. And Commissioner, I'm just curious what your characterization of that exchange might be for the discussion here before the board.
Commissioner Lambert.
Mr. Chairman, Commissioner Stein, and the letter that is on attachment 10, Julie Eckman, really sort of expands on some of the issues I raised at the last meeting. That is, based on the information that we had at the time, there was not a conditional use permit in place, and that by virtue of that, if the Ericksons were going to proceed to mine, they would need a new conditional use permit, and that would trigger the requirement for a trout stream setback permit from the Department of Natural Resources, which was some of the new legislation of a year ago. And so there was discussion between our staff and Mr. Scanlon from the Houston County Zoning Administration about whether or not the permit was still valid. And I think in the interim, while we were transacting back and forth, the court actually acted and ruled on that question. Now, I understand that can still be appealed, but the writ of mandamus essentially says that there is not a standing conditional use permit. So the point I was going to get to at the last one is my belief that by virtue of that, if a new permit is issued by the county, it is a new permit, and it will require that the Ericksons file for a trout stream setback.
Thank you.
Further questions?
Second question,
yeah,
Mr. Chair, just perhaps, and Ms. Hedman, I don't know if you have had a chance to review the court's decision on the writ of mandamus, but just to ask about the applicability of environmental review requirements. Does the county, by virtue of this, I was looking at the court's conclusion in the writ that speaks to the applicability of any environmental review, and I wasn't clear if if the court took a position about any mandatory categories or applicability of environmental review in this in their decision. But if you could help me out with that, I'd appreciate it.
I'm happy to review it in detail, but I'd like to do that before responding, if that's okay.
Sure.
Other questions or comments? At this time, I'd like to ask Marilyn and Joanna, if you'd like to come up and make comments. Welcome to the committee, or to the board.
Thank you. Chairperson Frederickson, ladies and gentlemen of the board, thank you for this opportunity to address the Environmental Quality Board. My name is Marilyn Crown-Bonner, a lifelong resident of Houston County whose family first settled there in 1866. 7 subsequent generations of my family have chosen to call Houston County home. We, along with all Land Stewardship Project members, are greatly concerned about the Minnesota Sands LLC environmental impact statement issue to be taken up at your meeting today. An important development has occurred since you last met. Despite the fact the Erickson silica mine was still subject to environmental review, it appeared the county was going to move forward and permit it. Citizens felt forced to take court action to compel the county to follow the law. And on June 2nd, Judge Birnbaum signed a writ of mandamus declaring, number 1, the CUP issued on January 8th, 2008 has expired. 2, there is no existing CUP at this time for the site. 3, any application for a permit renewal must be rejected and returned. 4, any new application must be treated as an application for a new permit and be subject to current state law. 5, any new application is subject to the moratorium in effect on until March 2015. In light of this writ of mandamus, which is at the end of your packet in attachment 12, there is no urgency for this matter to be decided upon by the EQB. Under the writ, Houston County may not approve a permit for the Erickson mine until the county moratorium expires in March 2015, and any new permit is subject to current state law, which would require obtaining the DNR silica sand mining trout stream setback permit with its 1-year period of pre-application monitoring. This removes any need for the EQB to make a special decision outside of the normal environmental review scoping process on whether the Erickson silica sand mine is to be included in the Minnesota Sands LLC EIS. As Commissioner Stein pointed out at your last meeting, once the scoping process is complete, we will know what is included in the EIS, and therefore it will be clear what is out. Based upon the information Mr. Frick submitted, it appears the scoping may begin soon. However, if the board should decide to remove the Erickson silica sand mine from the EIS today, we believe such an order also needs to clarify the status of the environmental review at the site. The Erickson silica sand mine must complete a previously ordered environmental assessment worksheet before any permitting can begin. As you will remember, an EAW was ordered on the site by Houston County on August 7th, 2012, as a result of a citizen petition. Later, Houston County requested the EQB become the RGU on this project. and it be incorporated into the Minnesota Sands LLC EIS. If it is taken out of the EIS, the RGU for the EAW should be reassigned to the most appropriate agency. Since the project will require a DNR silica sand mining trout stream setback permit, we believe the more appropriate RGU would now be the DNR. To accomplish this, we would suggest the findings of fact, conclusion, and order be amended as follows. To findings of fact, add 1. The Erickson 19.11 acre mine will mine silica sand and is within a 1 mile of a designated trout stream. 2. In 2013, the Minnesota legislature passed legislation requiring new silica sand mines within a mile of a designated trout stream to obtain a silica sand mining trout stream setback permit from the DNR. 3. A previously issued conditional use permit for the Erickson quarry has expired, and the site currently has no permit to mine. So future mining is subject to the 2013 law. This has been affirmed by the courts. To conclusions, add 4. The Erickson 19.11 acre mine is required to obtain a DNR silica sand mining trout stream setback permit before any mining may take place. 5. The Erickson 19.11 acre mine is still subject to the previously ordered EAW, and the RGU is reassigned to the DNR. To order, add the EQB orders the EAW completed on the Erickson 19.11 acre mine site, and the RGU is reassigned to the DNR. The decision the Environmental Quality Board makes here regarding the Erickson mine and the Minnesota Sands LLC environmental impact statement has far-reaching repercussions for the health of the land and the health of the well-being of the people of southeastern Minnesota, as well as the integrity of the environmental review process. The importance of this decision cannot be overemphasized for the people of southeastern Minnesota. Thank you again for this opportunity to address the Environmental Quality Board and for your service to the state of Minnesota and the future well-being of her next 7 generations. Good day.
Thank you, Ms. Rupert.
Good afternoon, I'm Johanna Ruprecht. I'm an organizer with Land Stewardship Project in our Southeast Minnesota office, and I live in Winona, Minnesota. I'd like to add just a few comments. First of all, I wanted to mention that Kelly Stanage of Houston County, who many of you have met and have seen up here before, was intending to come up and speak to you also today. She had some problems due to the storms that we've had recently. She wasn't able to make it, so it's not always easy for folks from Southeast Minnesota to make it up to St. Paul for this sort of thing. So I wanted to comment briefly on an issue that I believe she brought up to you at the last meeting. I want to call your attention back again to the dissolution of contract document that was submitted dissolving the contract between Minnesota Sands and the Ericksons. And I believe there are a lot of outstanding questions as to whether that document has been fully executed or whether it even can be fully executed in light of the current situation. That document, purporting to be the dissolution of contract, includes in point 5, Tracy Erickson shall complete all matters necessary to obtain his existing permit from Houston County. That has not happened yet, and that may not be something that can ever happen because, as we've discussed under the writ of mandamus, there is no existing permit, and that was signed by the judge, and that is currently in place, as Commissioner Landwehr has mentioned as well. So just want you to keep that in mind when you're considering the decision about the relationship between Erickson and Minnesota Sands and whether that has been legally severed. Thank you for your time. Any questions?
Questions for either Ms. Beyer or Ms. Rupert? If not, thank you very much for taking the time to be here. Mr. Erickson, do you have your hand up back there?
I'll talk in a minute, I believe.
Pardon me?
I believe Attorney Squires from the county is going to speak.
Oh, okay. Welcome to the board. Please identify yourself.
Thank you. Good afternoon. Jay Squires with Rupp Anderson Squires Waldsperger. I've been working with the county over the last number of years on land use matters, including this matter.
Can you pull the mic in front of you, please?
Yes. It's important to clarify the writ that was included in your packet, because it's been referred to as the court order, and the court has made these determinations. That's not the case. Under the writ of mandamus statute, Chapter 586 is a statute. There's a two-step process, and if you look at the last page of the writ, it indicates that the county is to appear at a hearing and show cause as to why a further writ should not be issued. So in that respect, it's in the nature of an order to show cause. This writ is drafted by the applicant, so this was drafted by the landowners. It's presented to the judge signs the order, and then the next thing for the county to do is to answer the allegations in that writ. The county answered the writ, and under that statute, the answer is sufficient, a sufficient denial that then the matter is processed as any other civil action. So the court has not made any determinations on the merits of any of these issues, on whether the permit still exists, on how the county's moratorium applies to this particular issue. In fact, there's a hearing on Monday before the judge, Birnbaum, that signed the order where the parties will present their case, and one of the options that's being asked of the judge is to dismiss the case in its entirety. So just to be clear, the landowners have offered that to you and suggest that the judge has made all these determinations. That's not the case. Those are yet to come. The second point, a brief point I wanted to make, is that there have been a lot of issues in this case. This case has been layered upon layered, and it's very complex, and there are many local issues, and there's the issue before this board today on the issue of the EIS. But those issues that are involved in the mandamus proceeding, whether the landowner's entitled to renewal of the permit based on all the facts that occurred and how and when they occurred, how the county's moratorium applied, those are certainly local issues that the county has to grapple with and work out with the property owners and Mr. Erickson, unfortunately, in a judicial process. But those, excuse me, those really aren't the issues for this board. The issue at the EQB level is the issue as to whether the Erickson property is a related or a phased action under EQB rules based on the information available. That's your piece in this puzzle. The other issues, the concerns the property owner has, and the property owners have, and certainly they have a right to have those concerns should be worked through and addressed, and there are different processes that go on. Those concerns are not really relevant to the issue before you, and that's looking at the EQB rules, the definition of phased and related action with the information that's been provided to you. Is it the case that the Erickson property, in light of that information, is a related or phased action of the Minnesota Sands projects that exist in other areas? So those are the only comments that I have. I'd be happy to answer any questions that you have about the other things that have gone on in this case over the last number of years.
Mr. Chair.
Please.
Thank you, Mr. Squires, for presenting. My understanding is you're attorney representing the county board. Is that your?
That's correct.
You're under contract through the insurance trust. That's the relationship that exists?
No, not on these issues. When there was litigation that was covered by the county's insurance trust, they appointed me and their self-insurance pool, but that would have been the case, for example, with the underlying Minnesota Sands lawsuit from a number of years ago. But with respect to this particular issue, no, the county contracts with me directly to assist it.
Thank you. And so your presentation today is a county perspective. Would it be fair for me to characterize that as you're here representing the county board?
Yes.
Thank you.
Yes.
Further questions? If not, thank you very much,
Thank
Mr.
you.
Squires. And also, thank you again for reminding us, and if you read the resolution, that is exactly what the board is being asked to do. And it was also fairly clear in the finding of fact that our responsibility really goes directly to the issue that you outlined very well, and that is whether or not it is phased and connected. At this point, is there further comment or discussion? Again, you have finding of fact in your packet. And we also have a resolution. The resolution the Minnesota Environmental Quality Board regarding the removal of a site from the proposed Minnesota Sands LLC multi-site environmental impact statement ordered on March 20th of 2013. The resolution further states, be it resolved that the Minnesota Environmental Quality Board approves and adopts the findings of fact, conclusion, and order identifying the 19.11 acre Erickson proposed project as an action which is not phased and effectively removing it from the mines included in the Minnesota Sands LLC environmental impact statement.
Mr. Chair, at some point I'd like to
Commissioner Rothman.
offer an amendment to the findings of fact and conclusions of law in order. If it's in order now,
Well, I think we should get the resolution in front of us at this point in time, so a motion would be in order.
I will move the resolution as drafted.
There is a motion. Is there a second?
Second.
There is a second. Now, on the amendment.
So, Mr. Chair, on findings of fact number 8, as according to the terms of the dissolution of contract, I would add the 3 words, and testimony received, right before the comma.
Is there a second to the amendment?
I'll second.
There is. Now, further discussion on the amendment.
Let me just speak to it. I think that we had, in fact, even today and at the original hearing, a lot of testimony that explained the dissolution, and I think it was helpful to have that and should be referenced in our order here.
So on the motion as amended, Brian?
I was just curious, given the complexity of the documentation of this package, I wonder if we're going to add that comment and testimony received, if it should be specific to the EQB testimony provided at last month's meeting. It appears, I mean, it could be mistaken which testimony we're looking at when you look at the number of documents that we have here.
Mr. Chair, I mean, the intention here was to talk about just the testimony, not necessarily the documentation, so.
Correct. I'm just wondering what testimony received. Was the testimony received in the writ hearing, or was the testimony received? Oh, you're saying all testimonial?
It was that I intended to mean at the board meeting on this matter.
Right. And that's what I assumed you meant, but I don't know that somebody else could read this document and assume that that's what you meant.
Yeah.
On May 18th, if you just want to add.
Yeah, I'm fine either way, if you want to specify that way.
Friendly amendment to the amendment on May 18th.
Sure.
All right. You want to read the amendment as proposed?
And testimony received at the May 18th, 2014 EQB meeting.
Okay. Now, did we? Okay, any more discussion on this particular amendment? If not, what I'd like to do is just incorporate it into the motion, and then we'll vote on the motion.
The previous EQB meeting was May 21st, actually.
Was it May 21?
Thank you.
I was reading from the notes.
Further discussion on the amendment to the motion. John?
Chair, are we discussing the amendment or the motion in general? I'm sorry.
At this point in time, we're discussing the amendment.
Thank you.
All right, on the, let's then move, I'm getting a little out of sync here, unfortunately. Usually we vote an amendment, but I think we can incorporate the amendment as a friendly amendment and then move directly to the motion. So on the motion. You want us to vote on the amendment then? All right, all those in favor of the amendment, please say aye.
Aye.
Opposed, same sign. Motion carries. Now on the motion as amended. On the fine, well, it's the resolution, which includes the fine, as amended.
Mr. Chair.
We're gonna get this figured out here.
Thank you. I think Mr. Squires raised one important point that I just want to amplify, which is the citizens and property owners in the county have not fully addressed local concerns in this matter, and that there are significant local concerns yet to be addressed. And I'm going to vote in favor of this motion. I think that it's been clear how the county intends to operate, and Mr. Frick, from his corporate perspective, has declared his interest very clearly. I do, however, believe that there are still significant differences that need resolution, that the county needs to attend to, and I'm hopeful that Mr. Scanlon, when he hears about this, or I see him there, you are, that will generate meaningful discussion at the county office about how to address concerns that the residents have.
Thank you. Other comments?
Mr. Chairman, question as much as anything. I think it accurately pointed out we've got a pretty narrow question before us, whether or not these are phased actions or not, and the preponderance of evidence I've seen suggests these are not connected or phased actions. What if subsequently something turns up that shows these are phased actions, either during the preparation of the EIS or after the preparation of the EIS? Is there some recourse at that point in time? And maybe this is a question for Mr. Seifert or somebody who's got, or Leah, somebody who's got some expertise with it. Because it would seem as easy as it is to dissolve, it's just as easy to.
Okay.
Mr. Chair, members of the board, Mr. Linder, my name is Kate France, and I'm EQB staff and lead for the environmental review. And the question I understand is, if the scope of the environmental review in the EIS were to change, how would that be handled? And that would be reviewed in the amendments to the scoping decision. That's one point that we could look to. It's in chapter 4410 under 2100, the scoping process for the EIS. Basically what it describes is, once the scope is determined, if there's a change, then the RGU, being EQB in this case, for municipal stands, can go back to adequately rescope the EIS so that the project is accurately captured.
Mr. Chair, Kate, so it takes some time to do the EIS. We go through the EIS process, and it's still assumed that during that period of time, the scope is a number of projects. It doesn't include the Erickson mine. Subsequent to the completion of the EIS, it's found out that there is a connection. What's the recourse at that point in time? Because then the project is substantially changed from that which was scoped and subsequent EIS developed.
Mr. Chair, members of the board, one of the clauses that is included in the rule offers the RGU the opportunity for, if there is a change in the project between when the environmental review is completed and all governmental actions have been completed, but not all construction has been done, there is an opportunity to go back to review the project. Now that typically occurs at an EAW level, but there will be opportunities for discretionary review should you choose to follow that.
All right. Thank you.
Mr. Chairman, just thinking through this while we're sitting here, so I apologize for the dragging on here, but so, you know, how would that impact the actual operation? So the EIS, a permit can be issued to Minnesota Sands subsequent to the development of an EIS. If an operation was not originally scoped in the EIS, but it is later determined that that operation has been ongoing with a business relationship that wasn't identified it's not there's no recourse for the EQB in terms of the operation of the mine, correct? It becomes our local unit of government issue at that point in time?
Mr. Chair, members of the board, and Mr. Commissioner, if there is no pending governmental action, if there were no new CUP or no interim use permit, then there can be no environmental review applied. And so that might be where you have some questions here. Is environmental review is ultimately a planning process. So if there is no pending governmental decision, you're right, there would be some challenges to include that. But if there are other projects that are planned or projects that you plan to expand associated with Minnesota Sands, that could be incorporated into the scope of the EIS.
Yeah, Ms. Edmonton also lend some knowledge.
I don't disagree with what EQB staff has said. In addition, under 4410.3000 supplementing an EIS, should there be a substantial change have been made in the proposed project that affects the potential significant adverse environmental effects of the project, that's one of the examples. But what you're almost referring to sounds as though, I mean, if you have questions of the project proposer here today with regard to the Minnesota Sands EIS, I think they're present. And you also, within the friendly amendment, have now added the testimony that EQB received last board meeting in May of 2014. So they did make several statements on the record to this board. So if they were to go against those statements and actually have a contractual relationship with which they've expressed to this board is not happening, it would be somewhat of a fraud upon this board. So I think that a supplemental EIS could be ordered, and the project proposer would have to pay the additional costs for that and the costs of the original EIS. It's going to be more money because you have to redo everything you already did. So they pay for that in addition to going through time delays, etc. So there is, I mean, would be, you know, it would be a tantamount to fraud, I think, at this point with the things that have been made on the record.
Well, and Mr. Chairman, members, I think the reason that I'm kind of struggling with is I think in many cases the RGU is the same as the permitting authority. And that's not the case here. We're the RGU for the EIS, but we're not the RGU for the permitting. So if it rests in one entity and the RGU finds out that they have been misled, they have the direct permitting authority under which they can do a cease and desist, for instance, or something like that. I don't know if we have that authority as RGU for the EIS, but not the RGU for the subsequent permit, CUP. Please.
So 4410.3000 is supplementing EIS, and it says the RGU shall prepare a supplement to an EIS. So as the RGU for the Minnesota Sands EIS, EQB would have such authorities. So on that particular point, with regard to the CUP or something else, that would be maybe in the local hands of the local county authorities, I think.
And Mr. Chairman, I guess, sorry to belabor this, but presuming we got to that point, do we have the ability to do a stop order on a project? I mean, we don't have any permitting authority on a project, so we would engage in a supplemental EIS, but that doesn't necessarily have any impact on a particular project.
Sure.
Okay, I think you're asking me to do an unresearched legal question, so I don't know that I can confidently give you answers. There are legal mechanisms to pursue. I can think of, you know, similar to a stop work order, but like a temporary injunction, etc. But I don't know in terms of the applicability. I don't know that it's been done. Whether it could be done. I hate to expound on that today.
Okay.
Sorry, is that a bad answer? I actually want to research it.
Mr. Chair and Mr. Commissioner.
Yeah, go ahead.
Excuse me. I just wanted to add one point to that. Thank you for the addition, Ms. Hedman. That if there is the supplement for the EIS, then 4410-3100, the prohibition on final governmental actions would apply. So that the Minnesota rules does carry the weight of law. So again, we would have to consult with your Attorney General staff, but that prohibition on governmental actions would apply in that case for a supplemental EIS.
Further questions or comments on the motion as amended? If not, all those, I think probably we need a roll call on this. I'll ask Will to call the roll on the motion as amended.
On the motion to adopt the resolution and findings as amended, Chair Frederickson,
Yes.
Commissioner Clark-Steven,
Yes.
Ms. Heidi Tollefson,
Abstain.
Commissioner Ellinger,
Yes.
Ms. Gehring,
Yes.
Commissioner Landwehr,
Yes.
Commissioner Knapstad,
Yes.
Commissioner Rothman,
Yes.
Mr. Saxon,
Yes.
Commissioner Linkstein,
Yes.
Mr. Erickson, or pardon me, Mr. Tomlinson.
Yes.
Ten.
There being 10 ayes and 1 abstaining, the motion prevails. Is Mr. Frick here? Can you tell me, in your letter of May 29th, Mr. Frick, you reference Roger Dabblestein in Fillmore County, and then in Winona County, you reference Mr. Roger Dobbelstein. Are they one and the same, or?
Yeah, they're just the property in Winona and Fillmore.
But you spell them D-O-B-B-L-E-S-T-E-I-N?
That's my fault.
Okay, so it's the same person?
It's the same person.
All right.
Same
okay.
as Harry Kessler, just that these two landowners have property in Winona and Fillmore County.
I see.
And you gotta do it on all of them, so.
You might want to redo that,
Yeah,
resubmit.
I
maybe.
will.
Will you? Okay,
Yep.
thank you.
And just one other question, is Houston County out of the EIS then?
I don't think that we addressed it from a county perspective. We addressed it from an individual perspective, Mr. Erickson's
Yeah.
mine.
Well, I just.
That 19.11 acre
Yeah,
lot.
can you make a ruling on that?
That we
Houston
take the
County's
entire
not in?
county out, I would doubt that would be,
If the county brings forward a request at a later date, we can consider.
please.
Sure, the issue is not before us today, Mr. Frick. If the county has an additional request they want to bring forward to the board for consideration, there's a pathway to resolving those issues.
Yeah, the reason I give you everything is that I'm not doing it on Houston County.
Mhm. Yeah, I think you said something to when hell freezes over or something like that.
But
I thought so, yeah. All
I just
right.
want to make that clear.
Yeah, I think we
I
got
already
it.
talked to Denise, and I'll return submit that list to Will, and I'll have the spelling right.
Yeah, okay, good. Further business that should come before the board? Hearing none,
Move to adjourn.
a motion to adjourn, is there a second?
Second.
There is, all those in favor say aye.
Aye.
Opposed, same sign, motion carries. Thank you.